Course Artificial Intelligence, Law and Justice, Session 24. Responsible AI in Law and Justice in India. Let us do a recap of the previous session. In the previous session, we did and discuss about RAI or Responsible AI in Law and Justice and the issues and challenges in that. We pointed out that while there is a broad consensus on the principles of AI, translating that into practice in law and justice has seen varied responses. Further, we also mentioned that responsible AI in law and justice might mean different things to different stakeholders, and preferences in values in RAI will make a difference. So, having seen the responsible AI as an idea, and then how it is getting translated in law and justice in different contexts with different stakeholders, let us move on to the current topic, that is RAI in law and justice in India. See, responsible AI in India is discussed by many people, including NASSCOM. NASSCOM has come out with a playbook for developers. Digital Futures Laboratory, a civil society organization, has also come up with a playbook. We have earlier cited the work of Vidhi's report on responsible AI in law and justice in India, particularly in the context of courts. In 21 and 22, NITI Aayog published documents on responsible AI in India with the slogan AI for all. So there it identified the core principles and followed that with two case studies. One case study on facial recognition technology. The second case study was on DigiYatra. And as we have said, NASSCOM and DFL have also published something. In 2023, NASSCOM published a report on state of responsible AI in India. So that report said, by and large, India is well prepared and Indian business are gearing up steadily for AI adoption. Further, it said that business is reporting higher if AI maturity also tend to be higher for responsible AI maturity. It also said larger enterprises are much better suited than startups and SMEs for dealing with responsible AI. Further, it said developers are better to use responsible AI principles than others. And then it also pointed out that business or across key industries are progressing while the satisfactory levels of RAI maturity. Then it also found that workforce development remains a major big challenge, and then for robust RAI implementation this could be constrained. Then business leads tend to feel most confident about meeting around data protection, and so that seems to be the constraint. So it said that data protection could become a major issue for RAI. Then the third set of findings was that business is moving towards compliance for RAI compliance, and then AI ethics bodies are being set up in different organizations in the sense that they are in the process of setting up those. Then it said lack of access to high quality data, shortage of skilled educated labor force, and then management personnel could be a constraint for RAI implementation. Other words, it says that high quality data and then availability of skilled persons in responsible AI could be a constraint for India. Of course, NASSCOM study was done on a very smaller sample survey. Again, it was based on interviews. Again, let us also take into account that NASSCOM represents a key industry stakeholder, that is a software service and software and IT service industry in India. So its findings are very important. And then the NASSCOM developers playbook on RAI in India, it gives guidance on risk mitigation for three types of AI applications. One, discriminative AI application. Two, general AI model, and then three, for any AI application. While this playbook is very important from a developer's perspective because it tells what should be looked into, what needs to be gathered into, and how to go about risk mitigation, identifying the stakeholders, particularly taking into account what are the various things that need to be factored in if you want to implement RAI. This playbook actually also relies upon the UNESCO ethics principle and then other guidelines that are generally acceptable. While this is not directly applicable to law and justice, it can be adapted for developing responsible AI in law and justice. Whereas the DFL playbook on RAI refers to UNESCO's AI ethics principles and it is meant for social impact organizations. So while this is useful, it has got very limited purpose in the sense that it is oriented towards social impact organizations. On the other hand, ICMR's ethical guidelines for application of artificial intelligence in biomedical research in healthcare is another document that mentioned about RA in India. But again, here the focus is more on biomedical research in healthcare. So that is again is a totally different area from law and justice. So we do not have much to pick up from that for developing RA in India in the context of law and justice. In January 2025, a multi-stakeholder forum of the Ministry of Electronics and Information Technology published a document outlining AI governance principles for mitigating AI harms and then to promote RA. So that document was again based on lots of stakeholder consultation. It itself had stakeholder representation, identified some principles for RA principles for India. This again has been based on the OECD ethical guidelines and other documents, and particularly the Global Partnership on AI's documents. So it identified transparency. Then it defined transparency as AI systems should be accompanied with meaningful information on their development, processes, capabilities, limitations, and should be interpretable, explainable as appropriate. Users should know when they are dealing with AI. So this is the first principle. Then comes accountability. Developers and deployers should take responsibility for the functioning and outcome of AI systems and for respect of user rights, the rule of law, and the above principle. So mechanism should be in place to clarify accountability. This again is something which we have seen even earlier, that when it comes to RA, accountability is a key parameter there. Then safety, reliability and robustness. AI systems should be developed, deployed and used in a safe, reliable and robust way so that they are resilient to risks, errors or inconsistencies, and the scope for misuse and inappropriate use is reduced, and the unintended or unexpected adverse outcomes are identified and mitigated. So this is although it is stated in a single sentence, this is a issue of huge high order, because they are trying to combine three important things: safety, reliability and robustness. While safety and reliability can be easily defined, robustness can be tested only over a period of time. In the sense that no system can be certified to be 100% robust the moment it is developed and started deploying. And then AI systems should be regularly monitored to ensure that they operate in accordance with their specification and perform the intended functions. This is again obvious, but the regular monitoring is a key question, because in any system, if the regular monitoring is to be done by third party for external evaluation and then for vetting, or it should be done by the internal processes, is again a big question there. If it is going to be done by third party, then there should be very specific clear-cut standards so that the third party can assess whether the system is able to meet those high standards. But if it's going to be something internal, then the problem would be that the internal process should be vetted by third party, or should be very closer to or identical the industry standards on that. Otherwise, what will happen is that this could again become yet another matter of ticking the boxes. And then privacy and security. AI systems should be developed and deployed and used in compliance with applicable data protection laws and in ways that respect users' privacy. Mechanisms should be in place to data quality, data integrity and security by design. This again is very important, but the problem here is that to translate this into practice fully, you need a data protection regime in place, well designed, well developed data protection regime in place, and more importantly, when it says data quality, data integrity and security by design again has to be standardized or has to be meet some standards. So someone will have to certify that security by design is fully applicable here and all the standards have been met. Then fairness and non-discrimination. AI systems should be developed, deployed and used in a way that fair and inclusive and for all, and that do not discriminate or perpetuate biases or prejudices against or preferences in favor of individuals, communities or groups. This again is something of a high order, for the simple reason it tries to combine fair, inclusive and for all, and that do not discriminate on the basis of this. This again is, as we said, is something of a high order, but again problem implementation would be that if you are going to apply non-discrimination fully, you will be finding it difficult to bring in certain things where you can accommodate certain groups to have representativeness built in here. So in practice, it could also mean that whom to bring in, whom should not be discriminated, how to make it fully representative may not be something that meets 100% the criteria of non-discrimination. This is something very similar to reservation in education and employment. Reservation in education and employment is called affirmative action, or it is done for a specific purpose so that there is access and availability for people who otherwise will be left out. But combining that with the principle of equality, the government and the courts have devised so many systems that they can balance the what otherwise appears to be mutually inconsistent rules. So similar rules will need to be applied when we talk of RA principles, particularly in law and justice. So this fairness and non-discrimination, translating that to specific guidelines and then to rules, we will need to keep in mind that India has also got policies for affirmative action, which are also known as reservations, and then lot of things can be learnt from that in to strike a balance between fairness and non-discrimination and provision for representation of those who are underrepresented. Then of course the human-centered, do no harm value, all these things are obvious. It should be subject to human oversight, judgment and intervention as appropriate to prevent undue reliance on AI systems and to address complex ethical dilemmas that such systems may encounter. Mechanisms should be in place to respect rule of law and mitigate adverse outcomes on society. For this also we have seen that there are lots of ways to handle it, and we have also noted that RAI can be looked in a technical perspective and again from a social technical perspective as well. So here we need to bring in the technical perspective, the non-technical broader societal perspective, so that both can be balanced together. And of course inclusive and sustainable innovation, the deployment and development should be to distribute the benefits of innovation equitably. This will need lots and lots of work to be done. For the simple reason, we do not attribute this inclusive and sustainable innovation to AI systems. Whereas we talk of inclusion in the broader way of the data should be inclusive, the algorithm should not discriminate, and then the training model should not discriminate. But when we talk of inclusive innovation and sustainable innovation, it means that the benefits of the innovation should be distributed equitably. How will we do it in a AI system is a matter of debate, because AI systems are not meant to bring in equitable distribution per se. That is not the objective. Often AI systems are meant to achieve some goals, including business goals. So all AI systems should be used to pursue beneficial outcomes for all and for deliverable on sustainable goals. Again, is a very challenging, if not impossible, goal to meet. Why again is the problem is that AI's role in sustainable development goals is well recognized, and then there's an increasing amount of literature on it. At the same time, as we have seen, that AI is also posing a huge issue in terms of resource utilization, resource allocation, and particularly in the context of huge demand for energy, water and other resources. So is AI is really a sustainable innovation is a hotly debated topic. So if we take that into account, how to make AI systems as inclusive and sustainable is a matter of debate, and maybe here we would need lots of standards and lot of deliberation to understand how to translate these things into practice. Then digital by design governance. So here the idea is that to leverage digital technologies to rethink and re-engineer systems and processes for governance, regulation, compliance, to adopt appropriate techno-legal measures as may be necessary to effectively operationalize these principles and to enable compliance with applicable law. So the eighth criteria is something that sets the bar very high, in the sense that it says that digital by design governance should take into account appropriate technological and techno-legal measures as may be necessary. So if these 8 principles are met and met in full, we can claim that those 8 principles or the system is something that can meet the goal or that can be classified as responsible AI system. So NITI came up earlier with its own guidelines or on broad guidelines on REI principles, and then NITI work was much earlier. See, when NITI started working on this field in 21 and 22, the idea of REI was developed, but then was not so developed as it is now. On the contrary, at that time, REI was more or less in the shaping, or was in the sense that it was in the evolutionary phase. So NITI took into account the developments at that time, identified again OECD principles, AI ethics principles of UNESCO, and then various other guidelines, and then identified a set of principles. Principles of safety and reliability, principles of equality, principles of inclusivity and non-discrimination, principles of privacy and security, principles of transparency, principle of accountability, principle of protection and reinforcement of positive human values. So the last one, principle for protection and enforcement of positive human values, means AI should promote positive human values and do not disturb in any way the social harmony in community relationships. This again is something which is very difficult to expect from AI, because for the simple reason, most systems developed in AI are not the ones that will be directly dealing with social harmony or with the idea of the promoting positive human values. So NITI's AI principles are well intended and done with lot of interest and done with lot of care. But if you look at both the committee's recommendations as well as NITI's RAI principles, there is a bit of overlap, but then they also differ. Here, particularly if we compare them side by side, we would realize that the same terms may be used in different ways. For example, equality is mentioned here. There, equality is mentioned not by the word very explicitly as equality, but through non-discrimination, inclusion and all. So, idea here is again privacy and security, it is also mentioned there. So, what happens in REI or responsible AI literature or lingo particularly is that certain things are mentioned in a very positive way. For example, principle of equality or non-discrimination. Certain things are mentioned in a way that is not exactly positive, but then to say that system should not be non-discriminatory, non-biased, etc., etc. So, what is exactly is covered by equality will also be mapped by non-discriminatory, non-biased, etc. But as the terms vary, the problem comes in translating that into practice. Because it is easy to say what is equality and then identify we are giving equal opportunities to all. The system is devised in such a way that it treats all the individuals as equals. But as we said, in some circumstances, particularly in a country like India, where there are principles of affirmative action and inclusion, so the equality needs to go something that is non-discrimination, beyond non-discrimination. It has to account for representation of those who are otherwise likely to get excluded. So the challenge in translating the NITI's REI principles as well as the earlier ones which we saw at that of the committee appointed by MITI lies in precisely first defining what exactly we mean by equality, non-discrimination and the non-bias. Second, the problem also comes that how do we prioritize among these 7 or 8 or 10 values? In the sense that when we develop an AI system, which one are the core ones that should be there at all? Or can we say that all the 10 or all the 7 are equally important? It could be said that all the 7 are equally important, but then the problem is that mapping these things into principles and then to guidelines and then to see how they need to be incorporated in the rules for developers is the real challenge. Of course, companies have come up with some rule books, some guidances, and then a lot of companies including Google, Microsoft, Apple are working on various principles. So there is a lot to pick up from that. Even the book, the developers Playbook by NASSCOM itself has got good examples. So certain things can be picked up from there. But the real problem when it comes to, particularly in the context of law and justice, is that given the wide diversity of AI systems that will be developed or that are being developed across sectors, how do we make them sector specific? For example, what is equality in one sector has to be clearly defined or has to be clearly mentioned. But then equality in another sector may be totally different. For example, equality in employment law is very different from equality in some other sector, because there the purpose of the AI system must also be in align with the sectoral or the legal values of that specific sector. So translating these into practice is a real challenge. So having said that, we will look into now what is NITI's work on facial recognition technology and responsible AI. So NITI did apply these principles to facial recognition technology as it is being practiced elsewhere, and also looked at what is being done in India, particularly in DG Yatra. It came up with a series of recommendations for policymakers and others. I am not repeating the same thing here for two reasons. One, this was done in 2022. Today, if the same work has to be done on FRT, we need to revisit many of them and then to update them and then to see that today's technology, what are the major issues when we think of applying facial recognition technology, particularly in India and in the context of apps like DG Yatra. Then the second point is that facial recognition technology is being used in India now in different places, in different contexts, but then so far we do not have a specific law to regulate it or to govern it. So the lack of a specific regulation or guidance is also a major factor. So if we have to re-evaluate NITI's work on FRT and RAI, we need to understand that in the specific context. So it gave emphasis to principle of accountability, principles of transparency, privacy by design, principle of protection, and reinforcement of positive human values. Now this reinforcement of positive human values, even if you take that out as something that is very vague or very difficult to translate into practice, the other four are very core ones that should be applicable for any facial recognition technology app or application. But NITI also said we need a comprehensive data protection act. And that act has been now brought in, but the full implementation has not taken place. The rules have been notified, rules have been also getting implemented, but then the whole gamut of rules are not in place. And then the authority is not in place. And then NITI's work can be compared with what is discussed in the literature. For example, I am citing an article in the Indian Journal of Law and Technology where this was mentioned. I mean, similar ideas were put up for risks on automated facial recognition technologies in Indian law enforcement. So, by now we have seen a couple of examples where the ideas of RAI are getting translated into practice either through guidelines or through principles or through specific guidelines to developers. But the real challenge in the context of law and justice is much more complex, for the simple reason we have discussed that RAI in law and justice is discussed in the literature, but then there is not much is available. And there are gaps in the literature itself, and then the following are the one that could hinder fuller development of realization of responsible AI in law and justice. We did discuss in brief the criticism by Vidhi on the responsible AI in the judicial sector in India. We cited that. That is one thing we can keep in mind. But let us look at the broader picture. As of now, the DPDP Act is not yet to be implemented full scale. So translating RAI in law and justice would definitely need something that would work only when there's a data protection authority, the rules are in place, the mechanisms are in place, and then it is enforced fully. Then we do have only very limited studies on responsible AI in India, and particularly in the context of law, that's much more limited. But non-availability of these studies is also a concerning factor, because as we have discussed in so many previous instances, we need to contextualize RAI in law and justice, particularly in light of the earlier points we raised in the context of automated decision making, AI and rule of law. and of course AI is application in different laws is something which can we can set aside for a moment. And we also need to look into the way algorithms are being regulated in India. So we need more studies, and then including the algorithms, we need to see how they are getting implemented, what are the guidelines, if any, available, what is the pros and cons of the current guidelines and then current implementation. Then we do not have a governance framework for AI, including algorithms and deployment of ADM in India. This again is a larger problem of there is a non-availability of a governance framework for AI. Government of India has not come up with governance framework for AI because the idea seems to be that government wants to promote innovation and does not want to bring upfront a governance regime which will more or less regulate the industry. So government's role or government's intention as of now is that not to go for a comprehensive binding regulation of AI or governance of AI, but to take things to evolve over a period of time, in the sense that look at first the risk and safety angle, allow for some voluntary guidelines from the industry, and then the MITI's committee came up with some recommendations on AI governance principles, see that how that gets translated into practice in specific sectors. So, but if we have a full-fledged AI governance, it will be easy for that to get implemented into law and justice more specifically. For example, the EU's GDPR Act is something that can be translated into data protection, privacy, and then whole lot of other related concerns when we apply AI. Similarly, a broader act like EU AI Act will cover many aspects relating to law and justice, particularly algorithmic discrimination, bias, non-discrimination in nature, and then privacy protection by the act itself. Translating those specific principles in law and justice can be done easily by borrowing certain articles, relevant articles and provisions, and linking that with other relevant articles and provisions. And that will be something that will really guide or enable developers as well as other stakeholders to understand as to what exactly they should do. In the absence of a governance mechanism, there will be a lot of questions that would remain unanswered. Then coming to the specific sector, we don't have any guidelines for advocates and courts and others on using AI. Of course, Supreme Court has come up with certain things in the sense that Supreme Court is doing what it needs to be done at that level. And then there is a lot of clarity. There is a lot of clarity available among the judges, among advocates on what to do, what not to do on when it comes to AI. And it has been again made time and again clear that AI should not be used for writing judgments or for decision making. But what exactly should be done, guidelines that will help the advocates and others to understand tools, what they should do or some specific circumstances, what they should avoid at all costs is not available. More importantly, we don't have any guidelines for assessment of AI systems in law and justice, but again, this again a problem of the larger thing where we don't have any guidelines to assess AI systems. Of course, there are a lot of guidelines available from private players. Private industry has its own set of guidelines which either given by those who develop systems or by consultants or by various agencies. And there is no specific policy on responsible AI in law and justice in India, which is again something we need to mention. Although there are a lot of things are happening in AI in the context of law and justice in India, we don't have a clear-cut policy as to which apps or which should be given prioritized, and then who will be coordinating what, or what exactly is the role of state in that, whether the state and private players will come together and come up with voluntary guidelines for regulation or for guidelines for assessment is not clear. And one important gap in this that the lack of information on use of predictive policing in India. If predictive policing in India is being used, but then there is no literature that really maps what is happening in India. There are reports here and there. For example, I have given one. CMAPS, predictive polling software that determines hotspots in the city and used to decide how much force is required for law and order and where to be deployed. A 2019 report status of policing in India cites this. But there is no comprehensive study on such use elsewhere in India, and as far as I know, there is only one study again based on the Delhi one, based by Shivangi Narayan, It's more like her thesis, which looked into how Delhi police uses predictive police for crime control and then for management and then identifying potential spots where crime can take place. But we really do not know as to who are all the other police who are using predictive policing and under what guidelines and rules they are being done. So as I said, we don't have case studies, we don't have a lot of literature available on algorithmic auditing, we don't have literature available on how do we deal with algorithmic decision making and then whole lot of issues. So in the absence of all this, translating RAI into law and justice is really a big challenge in India. But let us look at the positive side as well. On the positive side, you would find that there is a lot of awareness on RAI in India, which we can also see in many legal websites, and then by many people who are writing about it. Groups like Vidhi and Daksh are working on it. Daksh is again a civil society group that is working specifically on technology law interface. They have also done a lot of work in it. And then there are also organizations like Agami. Agami again is a public interest organization working very closely with the stakeholders to bring AI into law and justice, particularly for apps that could benefit the larger public, and also to make AI available through law and justice access available through AI. So there are institutions like Agami, there are other initiatives which are working on various tools for enhancing access to justice in India. So based upon all this, we can say responsible AI in law and justice in India needs a nuanced balance between innovation and safeguarding citizens' fundamental rights. For this, we need inter alia a robust regulatory frameworks, accountability mechanisms, guidance on ADM, and a functioning data protection regime. So, if these things were to materialize, translating the RAI principles in law and justice would be much more easier or could be done in a much better and faster way. But since there are so many constraints already there, talking of responsible AI in law and justice in India is very relevant, so that at least there is some nudging towards translating this into practice. But irrespective of that, within the next 4 or 5 years, as things converge, the sense that a fully functional data protection regime, availability of guidelines, and then other materials for guiding various stakeholders, and then various pulls and pressures from different stakeholders is likely to result in translating RAI in law and justice in India in the next 5 years also. So with this we have covered responsible AI in detail as responsible AI as a concept and practice, responsible AI in the broader context of law and justice, where we discussed about what is happening in different countries, and the specific context of India, particularly responsible AI in the context of law and justice in India. So having done this, let us move to an equally important topic, that is external AI. So in the next lecture, we will deal with external AI, and that will be followed by another lecture where we will go into the way we have done now. What do we mean by external AI in law and justice? Thank you.